There are a great number of reasons why you might not want to talk to the police at all. Even if you're completely innocent, you did nothing wrong, you think there's no chance of being involved in anything at all, there are still very good reasons why you may not want to say anything at all. And I'm going to explain some of those in this video. But also, because I'm a lawyer and I'm a barrister, I'm also going to explain to you why it might be a good idea to tell the police certain things in certain situations. And in true advocate fashion, you should hopefully be convinced by both of those. Because I always say to people, when you're watching a trial, particularly a jury trial, as a member of the jury perhaps, or even from the public gallery, when you listen to the prosecution case, and the way that the prosecution present the evidence, conducts their witnesses, and so on, you should very often be convinced that the prosecution have their case nailed and the defendant is guilty. However, I also say when you then hear the defense present their side of the arguments, they cross-examine the prosecution witnesses, they present and conduct their own witnesses, and then they give their own speech to you as the defense advocate, you should be equally convinced that the defendant is not guilty. And then you're left with a situation, well, what do I do? Because you're convinced by the prosecutor, first of all, and then you're convinced by the defense barrister. So I'm not really going to help you in deciding this. All I'm going to do is give you reasons for and reasons against saying anything at all to the police. Let's go. But before we get started, if I can just ask you one quick favour. I've been looking at my statistics just recently, and around 60% of you are not subscribed to this channel, that watch this channel on a regular basis. I would ask you very kindly to do that now, because it does help my channel grow and spread it to a wider audience so I can help more people to understand law. So let's get started. Let's start with one of the overarching reasons why you may not want to speak to the police at all. This is a fundamental concept and a principle which has been discussed worldwide, in fact, and it's something that you really need to take into account when you're having any conversation at all, let alone with the police. So you have to think about what the police are trained to do. The police are trained to investigate crimes or suspected offences, and they are trained, and it is their task to gather evidence. If they are speaking to you about it, that's exactly what they're doing, one or both of those. They're either investigating you for that offence, or they are investigating the offence, and by speaking to you, the police at least think there's a possibility of getting some evidence from you. Even if you were an innocent bystander, even if they're going door to door asking questions, one way or another, the police are looking to get evidence of a suspected offence that they are investigating. Why is that a problem? Well, it may be a problem for you in different situations, and I'll explain why. You see, the police investigating an offence know precisely what offence they are investigating, whereas you may not. They know precisely what elements of that offence, or at least they should know exactly what elements of that offence that they are investigating and what evidence they need to back those up. They also know why they're speaking to you and where the location is, what it is they're searching for, and what information they're trying to glean from you, and so on. And the only reason they can be doing any of this is to try to support one of these limbs of the offence that they must prove. Now, take the offence of theft, for example. Theft has 5 elements to it. It's the dishonest appropriation of property belonging to another with the permanent intention of depriving that person of it. Now, you may be involved in any one of these elements of the offence. Let's say, hypothetically, you borrowed something from a friend with full permission, full knowledge, and you thought nothing wrong in that whatsoever. So you've taken this item and you have it within your possession, and you, to your mind, you think you're borrowing it. However, what happens where you've fallen out with that friend and they've made a report to the police that you've stolen it? Clearly there is a dispute in fact here, because in your mind and in your knowledge you've borrowed this item, but then you've since fallen out with the friend. They've reported it as stolen. Well, as I said, there are a number of different elements of the offence of theft at play here. The one that your friend is going to struggle to prove is the dishonest intention part, with the intention to permanently deprive the person of it. However, at least one of those elements is already going to be proven if you have that item in your possession and you admit that to the police. That's the appropriation part. You will have appropriated that item in one sense or another because you have it in your house or wherever you've got it stored. So at least one of those elements of that offence has been made out. You have appropriated that property. Now, whether or not there is an intention to permanently deprive that item may come into play depending on how long you've got it. Because if the police want to prove that you intended to permanently deprive them of it, and let's say you've had it for 6 months because you fell out 6 months ago and you haven't rekindled the relationship with your friend since then, but you still have it, even in your mind, you might still intend to give it back to your friend whenever you make up with that friend. However, if it's still in your garage or your bedroom or your front room, your back room, your garden or shed, wherever it might be, if you still have that item and it's been a while, then the police might try to underpin this offence, the permanent intention part of that offence, because you've still got the thing. Now they've got two elements of this offence made out. You've appropriated it one way or another, and they will try to argue, or potentially try to argue, that you permanently intend to deprive them of it beyond any reasonable doubt because you've still got it some months later. Now, all of this, of course, may just be a perfect misunderstanding because you've fallen out with your friend, remember, and actually you borrowed the thing and you don't intend to permanently deprive them of it. It's not theft in your mind, and to a perfectly reasonable jury, you could explain this away perfectly innocently. However, when this questioning process begins and the police are just talking to you about this, whether it's on your doorstep or whether they've done it properly and they've cautioned you and taken you to the police station and they are questioning you there in the presence of a lawyer, which you're entitled to, but that's a whole other story. If they are questioning you about this and you are giving up this information, you may start to feel that you are going down in a spiral and you are giving the police information that they can then sort of use against you to make you feel guilty about this offence. If you start to feel guilty about this offence, then the police might press you for other details, the falling out, and the police might put it to you that you've decided to keep this thing because you've fallen out with your friend. If you say what I often refer to as the wrong thing, which I say the wrong thing because it may not be your real intention, it may not be what you really think, it may only be what you think in the heat of that moment because you've been questioned by the police. You have sort of given away a couple of the elements of the offence here, which even if you don't know what those elements are, it will certainly feel to you like you know that you've given something away. You might start to feel guilty. And the way that you come across in that interview and certain things that you say in that interview may make it sound that you are guiltier than you had once thought. So all of this that goes on, and the police know which buttons to press and they know how to question you. They are trained, remember, at questioning and interviewing people. And they think they've got a couple of the elements of this offence under their belt already. They might start to press you for more and more detail. Now, you can see from that why it could be very easy to say the wrong thing, such as, well, he doesn't want it anymore, or she doesn't want it anymore, or they don't deserve it back anymore, or they did X, Y, Z, so I deserve to keep it, or something along those lines. If you say anything like those things, even though you'd never probably thought them before, and you probably wouldn't really think about them if you were in an ordinary situation sitting in your living room and not being questioned by the police, and somebody said to you, what's that thing in the corner? And you said, well, that's just a friend's, we've fallen out. I'm going to give it back to him, but we haven't seen each other for months. Whereas if you say the wrong thing in the police interview, such as they don't deserve it back, that could allow the police to argue and charge you perhaps with the offence of theft on the basis that you've now said they don't deserve it back, which would underpin this element of the offence that you intend to keep it. Now this works backwards, because if you've appropriated property that belongs to another and they've now established that you intend to keep it, then they can fairly easily argue that at that point it was dishonest. Now remember, for these offences, they don't necessarily have to all occur at the same time and in a particular order. For example, if you've appropriated something with the knowledge and permission of the original owner, who in your mind still owns it and you intend to give it back, so you don't intend to permanently deprive them of it, but you say to the police that you've fallen out, he did X, Y, or Z and therefore doesn't deserve it back, and the police say, well, now you've intended to keep it. Now, working backwards, the dishonest intention to permanently deprive the person of it could then be worked backwards to argue that you dishonestly appropriated it in the first place. Now, any one of these things can arise from saying essentially the wrong thing, which may be something that you genuinely mean at that moment in time, but you possibly never thought about it beforehand. So you can now very easily see why and how you can say the wrong thing, and ultimately you might look back on that interview and think, I wish I never said anything, because they could never prove that I intended to keep it. Because after all, if you do go to a jury trial, you are charged and you're brought to court and you're brought to the Crown Court, which is quite likely for an offence of theft like this. You could always just leave it until you give evidence in court. That could be, I'm not suggesting it should be, but that could be the first time that you ever say anything about this accusation, and you say it to the jury during your own live evidence. Of course, you'll be cross-examined afterwards, and the strength of your evidence will be tested by the prosecutor in cross-examination. However, if you feel that you will come across more believable and more credible in the witness box, in court, to the jury, then you might think that's the best way of doing it, rather than let the police use what you may now feel like would have been a twisted interview evidence gathering exercise by the police. So on one hand, I might well have convinced you that it's better not to say anything to the police at all. Now, there is a caveat that comes with this, which is it may harm your defence if you do not mention when questioned something that you later rely on in court, and anything you do say may be given in evidence. The last bit of that phrase, the police caution, of course, which differs slightly depending on where you are, the last bit of that phrase is obviously a very good reason for not saying anything to the police, because anything you do say may be given in evidence. So if you say those things, it can be used in evidence. So let's say potentially you got something wrong, or you made something up, or you just said something that you didn't really mean, but you said it anyway. It's almost impossible to take that back, because the police can and will either read a transcript or play a video of your interview, and the jury will hear everything that you've said. So if what you now say in court doesn't accord with what you said in interview, then suddenly you're inconsistent, meaning you're not credible, meaning the jury will most likely convict you. However, winding back to the first part of that caution, it may harm your defence if you do not mention when questioned something you later rely on in court. Using the same example and the same scenario, you've borrowed something from a friend that you intended to give back, but then you were questioned by the police and they're asking you why you've still got it. It's been some months and so on and so forth. This time, in an effort to convince you that it could be a good idea to talk to the police about this, honestly, is because if you do not mention these things when questioned by the police, it may harm your defence later. And I'll tell you why. Let's take a look at this same scenario again. There is a simple explanation. You borrowed this thing from your friend some months ago, you've fallen out, and you've got text messages that confirm that you've fallen out. You've perhaps spoken to someone else about giving this thing back, or maybe even tried to give it back through a third party, and perhaps even you've tried to call this friend yourself to arrange dropping this thing back, all to no avail. So the thing still sits in your garage or your shed or wherever. You still have this thing. You don't want this thing anymore. You want to give it back to your friend, but perhaps even your friend said they don't want it back anymore or something like that. Any of these things are a simple explanation which would very likely acquit you of a charge of theft if you've got some evidence that backs it up and it's all a very believable story. However, link this in with the caution. It may harm your defence if you do not mention when questioned something that you later rely on in court. So now take the scenario that you've got all those answers which are perfectly credible, which you didn't say, but now you're standing in front of a jury and the prosecutor says the following. You have just said to this jury that you borrowed this item from your friend and you intended to give it back. That's right, isn't it? You will say, yes, that's right, that's what I said. The prosecutor might then say to you, at no point did you mention that you wanted to give this back before this trial. that's also true, isn't it? You'll have to say yes, because this would have been the first time that you have mentioned this fact. Let's say that you also say in your evidence at trial that you asked a third friend to give it back to this friend, but that person wasn't willing to come to court. And you're trying to get the jury to believe that you had this conversation with the third friend to return this item to the original friend. But what the prosecutor can then do in cross-examination is trap you into the evidence that you've just given in court as an inconsistency with what you've said or not said before. So let's say that you did make a defense statement, but you didn't include those facts because you didn't want to tell the police that. You didn't want to tell the police anything. Let's say your defense case statement, which is mandatory in the Crown Court, is a bare denial, which isn't a defence, by the way. A bare denial of the offence is not a defence in and of itself. But nonetheless, you've made this defence statement. You've given your response in a defence case statement as a bare denial to this charge. The prosecutor will then ask you that question. You've just given your evidence today that you tried to give it back through a third party. You'll say yes. The prosecutor might then say, just confirm to this court that is your evidence to this court today that you tried to give this back through a third party. You will say yes. You might even get frustrated because it might be 2 or 3 times the prosecutor asks you this same question. The prosecutor will then say you were arrested with this offence and asked to explain it by the police. You will say yes. The prosecutor will then say that you were interviewed about this offence. You will say yes. The prosecutor will say you had every opportunity to mention these facts to the police at that moment. That's right, isn't it? You will say yes. The prosecutor will say that you made this defence case statement setting out a denial of this offence. You will agree. The prosecutor will say that you had every opportunity to include those relevant facts within this defence case statement, and you will agree. The prosecutor may then remind you of how much time has passed between that date and the trial, which is going to be a reasonably long time, and then confirm with you again that you haven't mentioned these facts to anyone ever between those 2 dates, and you will have to agree. The prosecutor may then put to you that the only reason you're mentioning these facts now is because you've made it up. Of course, you will disagree with that statement. However, on the backdrop of all of the opportunity that you've had to mention these facts beforehand, you may now start to feel how a jury is going to doubt your word. Because so long as the prosecutor has put to you that you've made it up and given you the opportunity to deny and explain whether or not you've made it up, the prosecutor can suggest to the jury that you have just made this up in the witness box today, and that at no point have you mentioned this before. Therefore, how can that possibly be a credible account of what really happened? Now, the same is true not just for theft, but for any other kind of offence as well. Taking self-defence as a classic example. If somebody walks up to you and punches you and you punch them back in self-defence, that is a perfect self-defence scenario. You are acting lawfully because it's reasonable force, because you used not more than the force they've used against you. And it doesn't have to be the same, by the way, it just has to be reasonable in the circumstances that you genuinely believe them to be. What that means is if you genuinely believe someone is going to use a stick against you and actually it's an umbrella, then you use something against them. So long as you genuinely believe that that was the circumstances and the jury accepts that, then you can use reasonable force based on those circumstances. However, to summarise that same situation again, you're met with the same choice when speaking to the police. You can either speak to the police about your genuine belief that someone was coming to hit you with a big long stick, or you can feel rather embarrassed about it because it turned out to be an umbrella and prefer instead to say nothing. But the trouble is, if you wait until you get to court and then you say that you are acting in self-defence because you believed they were carrying a long stick and were going to hit you with it, whereas in fact it was an umbrella, you can see how you might struggle to get a jury to believe you that you haven't just made it up in court, whereas all along you were just acting in self-defence. So there are 2 sides to this coin, and hopefully you are convinced by both elements. One where you can say the wrong thing, either by being trapped by the line of questioning or by getting frustrated or by simply not knowing one of the elements of the offence that you are tripping yourself up on, because some offences are strict liability and you can be strictly liable to that offence. On the other hand, you could put the police to proof because the prosecutor have to prove the case against you, but if you've admitted it, you just give the game away. On the other hand, if they do end up proving that you had this substance, which is a strict liability offence, and later on you say that there was some legitimate reason for it, you'd found it and you were bringing it back to the police station, you can now see how the jury might not believe that. Whereas if that genuinely was the case in the first place, you could have told the police you found it on the floor, you picked it up and you took it straight to the nearest police station. There are various ways of validating that, and particularly if you did end up getting to the police station with it, that is obviously a very different scenario than being found with it somewhere else, at a club or wherever, and not saying anything at all until you get to trial, and then saying that you just found it in the toilets. You can probably understand how the jury might struggle to believe that. So if you found this fascinating, welcome to the world of law, welcome to the world of court, where hopefully you can see that there are always two sides, if not 3 or 4 or 50 different sides to a case. You can see things from different perspectives. I remember my very first legal experience, I was probably 16 years old. I was told to read a stack of 50 witness statements, 50, who the then lawyer said to me, "You've always been told that there are two sides to a story. Tell me how many sides you think there are after reading those witness statements." And I can tell you there weren't just 50, there were more than 50, because each person had a different story about other people who also saw it from a different perspective. So hopefully you can see just how interesting that might be, just how fraught it might be to answer the right question in the wrong way or answer the wrong question at all, and why it's so important that you seek formal legal advice. So my closing statement to you is, if you are ever questioned with something like this, always consider getting legal advice, even if you think you've done absolutely nothing wrong. Now, the only time this is absolutely not going to come into play is, let's say the police knocked my door now and said that I'm responsible for something that happened in Manchester an hour ago, and I can prove that I was here because I was in conference not much more than an hour ago and there was no way I was in Manchester, then obviously I can prove with GPS tracking and location and all of these sorts of things where I am, and therefore there was absolutely no way that I was in Manchester. But short of that, you can see how that can go wrong. I hope you enjoyed that. I hope you found it interesting. Please do remember to like the video and subscribe. And as always, thank you for watching.